Alright, so today we're going to be talking about the Supreme Court case Hazelwood School District versus Kuhlmeier. I'm going to try and go through this a little bit more quickly than I would like to, just because I only have 10 minutes on this program to record, so I'm just going to jump right into it. So basically what happened in this case was that students were in a journalism class at Hazelwood East High School, and they published a high school newspaper known as The Spectrum. Right before they published an issue, the principal reviewed it before it went to print, as was customary at the time, and he thought that two articles, one about a student blaming her father for a divorce and another about teenage pregnancy on campus, he felt that both of these were inappropriate. The divorce one he thought was one-sided, and that he thought the father should have been given the chance to respond, and the other he thought was a little bit too sensitive for the younger students in the class, and he also believed that the students who were identified as being pregnant in the article, who were interviewed, could have been identifiable, and their privacy could have been in jeopardy, even though their names were changed, and he thought that was inappropriate. So what he did was talk to their advisor, and they wound up cutting 2 whole pages of the paper, and you can see them there. So that effectively cut the length of the paper from 6 pages to 4, so by about a third. And students did not know about those retractions until the paper was printed and delivered to the school for distribution. So the students wound up suing the school district and claimed that their First Amendment rights had been violated, and they based their arguments predominantly off of the other landmark free speech and academic free speech case, Tinker versus Des Moines, which was the precedent of student speech protection. So ever since Tinker, whenever there were questions about free speech on campus, Tinker was a pretty high standard, and that was the case where some students wore black protest armbands to their classes, and ever since then, it was well over 100 cases had come through the courts, and almost all of them had wound up falling on the side of free speech because of the high standards set by Tinker. So what did the courts wind up saying? So it was first originally introduced into the district court. The students sued for injunctive relief and monetary damages, both of which were denied. So the court found that the school's actions were justified so long as the censorship was related to a legitimate educational concern with substantial and reasonable basis. So in effect, they said that, well, as long as the censorship on campus was about a class, about school, about protecting education, the educational goals of the institution, then it's okay. So the students appealed, and that decision was reversed. So the appeals court argued that it was a violation of the First Amendment because the school board could not argue that the censorship was, and I quote, necessary to avoid material and substantial interference with schoolwork or discipline or the rights of others. So after that appeal, the school board appealed again, and it wound up going up to the Supreme Court. The Supreme Court reversed the appeals court judgment and ruled that the principal was indeed allowed to censor the articles because the paper, from their view, was never intended to be a true public forum, but was instead a part of a school-sponsored journalism class. And they made a distinction between Tinker, which said that schools are not allowed to silence viewpoint-based speech of their students, but they said that in this case it's possible that people would have thought that in allowing any articles to be published in this paper, which was school-sponsored, that it could give the impression that the school was sponsoring these ideas, which they're not. Public schools especially are not allowed to do. So they argued that the court argued and ruled that prior restraint or censorship therefore is allowed as long as the censorship is reasonably related to legitimate pedagogical concerns. Now they still have to be viewpoint neutral in those censorships, so they couldn't, for example, censor a pro-life article but allow a pro-choice article or vice versa. So we have Justice William Brennan Jr. writing the dissent for the minority, arguing essentially that the idea of a clear pedagogical concern is too broad, is overbroad, and opens the door to unreasonable censorship. And you can read this quote here about, he says that if you talk about just some ideas written in the paper are upsetting the goals of the university, then you can make that about anything. You can make it about a student who's actively, you say that stands on a soapbox during calculus, actively interrupting class, to just someone who's wearing a shirt that may distract people, or someone who's talking about sex could go against the government policy of condemning teenage sex. So it's just, when does it end? He argued that it was a dangerous slippery slope. He also argued that the court's reasons for censoring for allowing the censorship of this paper were just not acceptable. He said that you can see a quote here from the principal where he said that the articles were censored because they were just too sensitive for, quote, our immature audience of readers. And he says the court's supposition that the principal intended for these generalities to be a lesson on the nuances of journalistic responsibility is utterly incredible, so just ridiculous. He thought that based on what the principal said just about feeling that some of the students would be offended or it would be too sensitive for them, has nothing to do with the university having to protect its pedagogical mission. It was just too vague, too narrow of an idea for him, and it just didn't make any sense, especially to make such a broad precedent with this case on. So what's happened since then? Well, in the footnotes, they indicated that this decision does not necessarily apply at the collegiate level. In high schools, this has been pretty much a game ender in this sense. Some states have passed laws that protect high school journalists, but they're pretty weak. Now, decisions since this decision, as regards to college media, have been pretty murky. A lot of different courts throughout the country have given opposing rulings. The Supreme Court has not touched the collegiate level yet. One that's often cited by colleges is that Hosty versus Carter is one instance where college media were also found to be eligible for censorship as an extension of Hazelwood. But it's a pretty weak case for a lot of colleges to make, because that case was only in effect in one district, and it's nullified there now because of a separate law. So it's a pretty murky area, but for the most part, colleges still give newspapers from higher education student journalism a lot more protection than high school newspapers. And we're going to see how that shakes out in the future as well. And again, in another case, the court found that subsidized school-sponsored publications like the one I work at, the Saber, still have full free speech protections, even though they're counted as school-sponsored publications because they're in higher education. But again, there are a lot of other cases now that say the opposite, so it's a very murky situation. And a lot of states, well over 20 states now, have passed specific legislation to protect student journalists, some of them high schools, like I said, and a lot of them more based on higher education. So this has been a major Supreme Court case. I've talked a lot with some people in FIRE, the Foundation for Individual Rights in Education, and this is a case that's really been a thorn in a lot of free speech advocates' side for a long time. So this is a pretty major one, and it's important to know it.